right, where we at? Line 9. And then it has lyrics. I don't know, Your Honor. Can look at the lyrics. I don't want to embarrass myself while I read it. Okay, so it says, and so the big thing there is the proverbial smoking gun is that this incident takes place, and months later, Mr. Bank puts out a song to celebrate it and commercialize it. Immediately, when we got in the case, we heard from people in the music industry. Why I feel like I read that? Is that just a repeat? I read that. So, okay, let's keep going. All right, and we kind of went into this situation the other night when we did the order for dismissal because they basically said that it was recorded in January 2022 with no edits as far as on Durk's behalf. Yeah, and we definitely already can see by just clicking on it and listening to the original song from Babyface Ray's YouTube account that that's different. It doesn't have Quando Rondo on there. You know what I'm saying? So yeah, I think they dropped the ball, especially so if this was presented that way to the grand jury, yeah, that's crazy. Okay. So basically that's what we read the other night. I'm not gonna go into that. All right, here we go. So Mr. Yanni, because I've been waiting to hear like what did the prosecutor say into this. So this is what it said. It says here, Your Honor, we actually object to this proffer, this line of argument. The bottom line is, here you go, there was a video that was filmed showing defendant's rival screaming, no, no, that was placed over these lyrics. So, independent of when the lyrics was actually written, and, hold on, written, where am I at? Oh, written, and whether this was about Mr. Banks sanctioning some other murder, which the government submitted evidence showing that there were other monetary bounties placed on rivals to solicit murder. So independent of who this was, ultimately that the commercialization and that this allegation is nonetheless valid. Hold on. Is that saying what I think it's saying? So hold on, y'all. I'm gonna read it one more time. The bottom line is that there was a video that was filmed showing defendant's rival screaming, no, no, that was placed over these lyrics. So independent of when the lyrics were actually written and whether this was about Mr. Banks sanctioning some other murder, which the government submitted evidence showing that there were other monetary bounties placed on rivals to solicit murder. So independent of who this was ultimately about, the commercialization and this allegation is nonetheless valid. So what they're saying is they know it's bad, that it wasn't Durk himself doing it, but because fans and YouTubers pieced it together that way, it was still a way of commercializing Durk part. What's up, Zaria? Now that's some ish. That's some ish. Damn, that's deep. So basically, how I'm taking, they're saying that, like, although Durk didn't put out the video with that being like that, he's benefiting from it though. Y'all agree with that? Do y'all agree with the feds where because YouTubers, content creators, fan pages are putting together these theories of content that it should fall on Durk? Is Durk benefiting from it? Blue said, nice try, but short miss. Yeah, because unless they explain it that way, like to me, and now remember, the issue is that they presented this to the grand jury. So unless they presented it like, hey, he played into this narrative to even content creators was able to piece it together and put out this narrative, which ultimately helped him grow as an artist or whatever. If they didn't say it that way, I don't see how that's gonna stand though. By just saying, oh yeah, he ain't doing it himself, but he benefited from them doing it. Do y'all agree that Durk benefited from that? From content creators pushing him to be like this mob boss or whatever online? Do y'all think that benefited him? That's crazy though. That's crazy. That's crazy. All right, let's keep going. All right, so now it says, and I'm at line 20. Hold on, let me see. Latrice, what's up? I'm gonna have to red ball this one back. Hey, it's crazy, okay? Zara said that's a deep question. He may have benefited from it, but it's not his fault. Right. You know what I'm saying? Negative publicity, because that's like, to me, right, when you put it, because how I think about it, you know how like the saying go, all publicity is good publicity, right? Even negative. And then you think about shit, not really. But ultimately it is, because it's like when something bad happens, it's up to that person. You can either let it destroy you, or you can make it work in your favor, or like use it to work for you. So even if YouTube is going crazy with all these theories, and as a content creator, like I'm not calling Durk to ask him like, yo, how should I do the content on you today? You know what I'm saying? I'm not doing it. Like I'm just gonna go off of how I feel about it and put it out. You know what I'm saying? So when I put it out, I'm thinking about how it's gonna benefit me and my channel. You know what I'm saying? And I feel like most creators, but I'm gonna speak for myself, you put out content that's gonna, get you, benefit you, whether it's your pockets, whether it's growth of your channel or whatever. You're not really worrying about what impact it's gonna do to the person that you're. Is that thunder? Or is that somebody moving their trash can? You know what I'm saying? So that's crazy. You know what I'm saying? Like, that's crazy. It's like when your name is out there for anything, drop your damn album. Right. So, that's a perfect one. Cause that's like, yeah. So is it your fault? You know what I'm saying? That somebody has created this narrative, you decide, well, fuck it. Everybody got my name, drop it. You know? Like, what else you supposed to do? That's something. Is that thunder? That's some churn with the trash can. It sounded like it was thunder. All right, let's keep going. So now his defense attorney is about to respond. Let me say this about this issue, because we really discussed the ethics of this situation. I'm at line 1. And I want counsel to know, I'm not saying counsel tried to slip one, by anybody, but I know that counsel relies on agents to make their case. They're not out there they're relying on agents to make this case. This was, here we go. Hold on, let me see what Blue said. Blue said he might have benefited, but he wasn't responsible for what or content creator put out. Correct, because like ain't nobody calling Durk to ask him what to put out. Maybe like people that's under him, but like YouTubers I doubt it's a YouTuber other than like Chicago-based YouTubers like Jay Main and them that probably could get in touch with him. You know what I'm saying? Like I doubt people is tapping in, or Durk is tapping in with YouTubers to say, hey, run this. You know what I'm saying? Ever since that storm, we don't play with that thing. I'm telling you, Latrice, because I'm over like, what is that? All right, I'm at line 6. This was presented to a grand jury, and respectfully, somebody testified in front of the grand jury about paragraph 6. And paragraph 6 does not echo the sentiment of what you just heard from the government. Paragraph 6, paragraph 6, as presented to a grand jury, specifically said that these lyrics were composed and produced to celebrate this shooting incident that is the heart of this case, and that this is preferably false. And had any of our clients who have been subpoenaed to a grand jury done something like that, they will be in big, big trouble. So this is an important issue when the court is determining, particularly the second part of this analysis, because we know the pretrial service report says, hey, we think under the right conditions, we can ensure that he will show up for court as required by your honor, but we're concerned about dangerousness. Can't get that word out either, okay? dangerousness. Whew, there you go. And this is as big as a fact as any when you read the indictment. I could tell you for what it's worth, it's the one the press wants to write about the most, and it's just false. Ooh. I think so. They basically lied. I'm gonna be honest. Because now they're saying it could be about, it may be about this murder, or it could be about the murder in Chicago because it was all these bounties. But if you told the jury that, no, this song is about this murder, right? Then you lied to get your true bill. That's crazy. They need to dismiss the case. Now, answer has not came back on it yet. I'm just saying my unwanted opinion. If this is true, and I feel like it's true because they're having this conversation in front of a judge, they need to throw out the case. And really, it probably ain't gonna help. Depends. I might say it probably ain't gonna help the other ones because, Durk went up before the grand jury after he got arrested. The rest of them got indicted prior. So if they didn't use that song then they ain't gonna benefit from it. But yeah, it's starting to look like they talking about he tried to flee, he tried to like scat. They had scat too much and they done effed up for real. Okay. All right, so let's keep going. All right, so here go Yanni again, Mr. Yanni. Y'all know that's our nickname, Mr. Yanni. Says, Your Honor, if I may just clarify the record, Mr. Finland was arguing. I understand very passionately about it. There's nothing in paragraph 6 that talks about when it was produced or written. So the government again objects with that, or objects to that characterization and disagrees with it. So it sounds like they need the damn grand jury transcripts because it seems like they're at a crossroads with exactly what was said to the grand jury, which is very important because what the defense is saying that was said is definitely something different than what they're saying now. What we're hearing. All right. So it said, all right, you can provide the information to my courtroom deputy. So I guess they might have the transcripts, okay? Oh, it's definitely gonna be interesting for sure. I'm not so on the motion paper it says like June 5th. So I'm not sure if that's when they're gonna have the hearing or not. But June 5th might be the date that they actually get the hearing scheduled. All right. So now it says, damn. I was just about to say I could probably go out there, but I forgot I'll be in Miami. But anyway, so Your Honor, regarding these relevant time periods that we are talking about, all we know is we got hit with something last night. About some confidential informant of what a confidential information says, but we have nothing presented by the government as part of this hearing that is showing any violent activity during this relevant time period by our client. I mean, I do these hearings relentlessly, and they're involving a shooting incident and a stabbing incident and a fighting incident. And other than some unknown incident that he's not charged for out of Chicago, there's no charges out of Chicago. Mr. Brayman has done a yeoman's job at trying to keep up with that. There's no apparent case in Chicago. We have nothing. The only thing that we are given is a dismissed case in Fulton County and some unknown person that's a corroborator that's casting allegation at our client. Oh, is it a YouTuber at this point? Because y'all remember O Block case was full of YouTubers. Is it a YouTuber that's a confidential informant? That's not, and let's say this. Hold on, I'm about to clarify something too. You gonna be in Miami? All right, hit my line. Yep, I'll be in Miami first week in June. All right, so now let me say this. Remember, the internet was on fire. That okay, listen, a co-conspirator, okay, would not be listed as a confidential informant. Okay, they'll be listed as a cooperating witness. Okay, because a confidential informant is just that they are working for the feds. We heard that. The last case we heard that on was what? The O Block case. Confidential informants are actually people on the payroll. Okay. All right. So that's interesting. Who could the confidential informant be though? You know what I'm saying? If I would have to guess, I think it's somebody from Chicago. I'm gonna be honest. Who, I don't know. I feel like it's probably gonna be somebody from Chicago. And the only reason why I say that is because they're like, hold on, where is it? Something about some confidential informant of what confidential informant says. We have nothing presented in part, and they keep bringing up stuff from Chicago. It makes me feel like it's somebody from Chicago. Like, I'm just gonna be honest. That's what I kind of feel. All right, let's keep going. We're making progress. All right, so I'm gonna start back over from line 10. The only thing that we are given is a dismissed case in Fulton County and some unknown person that's a corroborator that's casting allegation at our client. Other than that, there's nothing of substance to indicate that he is a perpetrator of violent activity, and particularly because this incident resulting in this case takes place in 2022. I mean, we're now in excess of 2 years goes by, and there's nothing to indicate that there's anything hands-on that he's been involved in. That's crazy to say, hands-on. The only thing he's been involved in is what I'm about to now turn to, and that is, and you'll know that in one of the footnotes, an agent says something to the effect that he tries to distance himself by involving himself in community service, and that can't be anything further from the truth. From 2020 through this period of time, while there's nothing provable, substantive that the government could tender you to show that he's a threat to people, that he's violent, okay, we can do that. We can show you exactly what Mr. Brayman was referencing, and that is robust community service that he's been involved in. Unidentified speaker, judgment, I approach, yes. Pause. Okay. We're not gonna talk about that. That's crazy. That's crazy. All right, so let's start at line 6. The government reference, and I said that there was kind of this conflating of him and only the family. Only the family, Your Honor, and I'll be happy to share with the court. Only the family was duly incorporated in 2012. We've interviewed extensively the transactional lawyer from Chicago that did that. It is a corporation, and at the same, as you can see that Mr. Banks, he eventually signs with Alamo, which is a division of Sony. The COO of Sony, of Alamo division of Sony, is here supporting him. If you'll be kind enough to stand up, so this division of Sony stands by his side, you can actually see that they have pledged that if he's able to put together his bail package, they will put up $1 million in cash to support him. All right. But that's him individually. But in the music world, as we have learned, there's your individual success. But what everybody wants to do is also start your own label. And that's what he did with OTL, Only the Family. Because to sign other people and to build your industry, you have a greater profit center. And that's what he did in 2012. And so in 2012, he duly incorporates and starts Only the Family. And then he grows. Okay. All right. We're not going to talk too much into that. Okay. Who is talking? Okay. So the feds are talking now. Okay. And says they interrupted and said, but Your Honor, we stipulate to the defendant being a successful music artist. This case isn't about that. It's about his control of the label that he referenced here, OTO. But more importantly, the violent crime that's at issue here. So, Your Honor asked counsel to address the specific issue of danger. And again, we don't see any of this as being relevant to that. Then Finley said, well, it is, Your Honor, because the indictment specifically, I think I read too much, specifically says that OTF is a violent gang. OTF is a duly incorporated organization that has reached a relationship through transactional lawyers with two major corporations. Corporations that vet the people that they do business with. I don't think a division of Sony is going to sit down and create a deal for hundreds of thousands of dollars with only the family, specifically Durk Banks, if they're through their vetting process, they thought that they are getting in bed with a criminal organization led by a criminal gang leader. I don't think that Alamo Records, another division of Sony, is going to do that either. I don't think that Empire Records out of San Francisco, extremely well known in corporate circles, is going to get into that relationship. So the government's picture that they're presented to Your Honor, and that this is in those documents that are part of the record, is that all he is a gang leader, and that's just not true. And so we don't know about the actions of others. We don't know what other people are responsible for, but we know this, that there is nothing that shows during this relevant time period other than complete conjecture that Durk Banks has himself done anything. And the reason those are relative facts is because you have to balance respectfully that conjecture from probable facts, because these are not provable facts. Whew, these are provable facts. So I appreciate the stipulation, because the stipulation is that he's a law-abiding citizen. God damn. Listen. Hey, they be killing me with their privilege. I'm telling you, okay? Whew. Oh, Zara says they'll get in bed with him for sure. All right, let's get. They saying the same word over and over. I'm tripping off of them. Okay. All right. That's an episode that you would expect someone to. Okay, we get it. The Bail Reform Act, we get that. His management want the court to know that in good faith he have case that we worked on it. I'll call it okay. That is just basically saying that, hey, he'll do this, he'll do that. If y'all let him out, we already know the gist of that because we done went over that. Okay. They talking about his properties. All right, this is pre-trial. Your Honors. All right, here go old Yanni again. So, Your Honor, most of what counsel just articulated again, I objected twice. I don't see it as responsive or relevant to the narrow issue before Your Honor. Whether or not conditions or combinations of conditions can reasonably assure the defendant's appearance or mitigate danger to the community. So, what essentially has been offered is Mr. Banks has offered a small portion of his net worth and then suretized by others, including a corporate surety, and then a security company that's offering physical security. As the allegation in this case makes abundantly clear, Mr. Banks wasn't on the street pulling the trigger. He was the one who was allegedly orchestrating it. He was given a green light to book the flight. Y'all see how they say green light? Green light to book flights. In fact, one of, as an OTF associate, somebody working for the label, was booking the flights for 5 co-conspirators to fly to LA to commit this murder. Mr. Banks, as alleged in the indictment, sends a text message, don't put my name on those flights. So Mr. Banks knew exactly what was going on, and he helped facilitate this murder as the leader of the organization. Now listen. So it's 5 people arrested with Durk, right? And y'all see how they refer to them as co-conspirators. So they're definitely not no confidential informant. Okay? Because they clearly just labeled them co-conspirators. Okay? And they would have been like 4 co-conspirators and 1 confidential informant. Okay? Just throw that out there. All right. What's next? All right, here we go. Counsel didn't really address much of what the indictment actually alleges and instead focus on a portion that reference rap lyrics. But we'll submit to your honor the indictment in lengthy and includes allegations that show Mr. Banks' significant involvement in the murder. With that, again, the murder was committed through intermediaries, and a physical surveillance company that counsel is offering to mitigate flight and danger really offers no mitigation to that. That he could steal nothing about that prevents him from intimidating witnesses, instructing intermediaries, sending text messages. So the government stands by its briefing and requests that the court detain the defendant. All right. Then, Finley want to say something. He said, if I can add, we'll be willing to surrender telephone communication devices. We've been, Ms. Goldberg and I have been through this before. If there's a rule regarding telephone communication devices, we would abide by that. And we also have reached out to a third party, which is unusual in federal cases. But if the court wanted a bonding company to be a third party involved, we've already made contact and have one that's willing to get involved if necessary. All right. So the defense rests. Okay, where we at? Like I always say, this is coming from Blue Nitty. The very thing they say is going to hang you can be the same thing that set Durk free. That's true. Mickey, help the slow bloggers out there using this thinking transcript from a bond hearing following the motion you just submitted Friday. Hold on. Help the slow bloggers out there that are using this thinking it's transcript from a bond hearing following. Oh, like they think this is a response to the motion to dismiss? Why did they think that? Yeah, I tell y'all, anybody can pull paperwork, but comprehension is at an all-time low. Because why did they think that? Definitely get y'all memberships, y'all, for real. Because I'm definitely, especially y'all know trials is starting to pick up. Paperwork gonna be dropping, so definitely tap in. But why? What? That's funny. All right. So this is what the court says. Okay. The court said I have reviewed the materials that were indicated at the beginning of the hearing, that identified at the beginning of the hearing, and I have also reviewed the materials that were submitted by the defense at the hearing. The e-ticket itinerary and receipt in the Neighborhood Hearings Foundation is like a printout from a slide deck that looks to be about 30 pages with counsel reference during the argument. All right. Based on the violations that are charged with which the defendant is charged in the first superseding indictment, there's a presumption in this case that the defendant is both a danger to the community and a risk of flight. The defense has the burden of producing or proffering evidence to refute the presumption, and the defense has proffered a considerable amount of evidence which the court has taken into account. The presumption does nevertheless remain in the case, although I will note that particularly with regards to the risk of flight, the defense has proffered considerable information, meaning they don't think he's a flight risk. And I recognize the community service that is reflected in the documents that have been provided by the defense. The issue before this court is very narrow, which is whether there are conditions or combination of conditions that can reasonably assure the safety of the community as well as the appearance of the defendant as required. It's not an issue before this court whether the defendant is or is not a member of a gang or how his family organization is characterized. Okay. So we already know she basically found that he was. Yeah. Because it said the defendant is in control of others. So the judge ultimately says, okay, I agree with the government that the presence of security company providing security for the defendant is not going to address the significant concerns with regards to safety of the community here. Because basically they say he can still pick up his phone. Hell, he could probably get the security to go do it, Chelsea said, man, if they're going back to murders way back as far as 2015, Durk will never get out because I'm sure it's witnesses for those two. It's not even about that. I said this on the other video, y'all. This is the thing. If the government lied to get the true bill, which is in the indictment, they could have 10 snitches, 10 witnesses, 10 murders. If it's all on this case and the government lied in the grand jury, it's out of there. Out of there. See, let me tell y'all, and I feel that sometimes I do it because I use that as example a lot, the O Block case, because that's like the most recent Fed case that we covered. But y'all, this the O Block case and the Durk case is two different situations. Okay. Two different situations. Although it ultimately is about a murder, it's two different situations. You know what I'm saying? So like the issue at hand with the Durk case, okay? Okay. The issue at hand with the Durk case is that what was presented to the grand jury. If they presented it the way they said at the bond hearing, they might be all right. But if they presented it the way that the defense said they did and they lied, it's gonna be an issue. Period. It ain't even about nothing more, nothing less. Moneybag said, "What witness? Oh, they got snitches on here. They already said they got at least one confidential informant that's already talking on Durk. Durk ain't coming home, y'all. I mean, I don't know if he coming home or not. Y'all be just quick. Damn. Y'all just be quick. Soon as the government drop an indictment, y'all like, oh, they ain't coming home. They ain't this. Like, damn, y'all don't give. Woo, shit. But it's wiretaps and snitches he sent to go do this mess. That's telling. Listen, Chelsea, you missing the whole point. You thinking too far into it. Listen, okay? I gave this example the other day. I'm gonna try to do the example again, okay? Your old lady got 5 kids, right? 5 kids. 5 kids. You think all 5 is yours, right? When they come out, all that, she said, yes, you're dead. Like, all 5. Eventually, you find out that only 4 is yours, right? So you like, okay, yeah, all right, cool. The 4 is mine, but what? This one not mine? You know, that's going to be the problem. You can't say, oh, but the other 4 is yours. Even though I messed up on the 5th one, the other 4 is yours. You can't do that. It's like the same thing with court. So, for example, they got the lyrics presented to the grand jury. They got witnesses. They got snitches. They got wiretaps. All that, right? And I still don't even know if they got wiretaps, but I'm just throwing that in there, right? They can have all that. But if they lied about one, even if they got the other 4, the focus is gonna be that one. That's what I'm trying to say. Like, y'all missing the point of what the defense, the whole thing about the defense is they're here to find the fuck up from the prosecution. So the fuck up from the prosecution as of right now, according to the defense, is that they lied to the grand jury. You can't do that. Meaning, now mind you, the grand jury is the prosecution's dance, right? The defense attorneys are not there. The defendants are not there. So that's their show. So if they lied, okay, that means that true bill, meaning the indictment, you know what I'm saying, is about to be void because you can't do that. Now, like I told y'all, if the prosecution didn't word it the way the defense is wording it, then they might be all right. If they said, like, hey, no, he ain't put it out this way, but because other people put it out this way, he benefited from it, then that's different. But if they did it like the defense said, and they said, hey, he used this to further his career, like he actually put it out, then that's lying. So, you know what I'm saying? So right now, that's what I'm saying. You get what I'm saying? That's basically what I was saying in my comment before. Like, yeah, it's like, you know, Black Butterfly said, I was cooking and listening. This is not related to the recent argument to dismiss, right? I'm getting thrown off by my fellow commenter. No, this is, okay, thank you. Yeah, this is the original bond hearing. This is the one from, let me go back up and show y'all. Because pretty much we're done. We made this a page 45. Y'all, we made it 45. But it got a date. That's why I don't know why anybody think this. And look, it's an exhibit. If it's a fresh hearing, y'all, and let me tell you, and maybe some content creators that might be lost, if you're doing this, exhibit means it's old. They're not going to, if we're in court right now having a hearing, the transcript from this hearing is not going to be an exhibit. You know what I'm saying? So this is from December 12th, 2024. So anybody, any content creator running that this is from now is, y'all need to just stick with me because obviously they don't know what they're doing. But as y'all can see, this is from December 12th, 2024. It's just, this is like, that's why I told y'all in the beginning, a lot of this we already know because we done broke down paperwork that came after. But this is just the official transcript of it. That's it. And like I said throughout the video, that's my opinion. And if you don't like it, guess what? I'm like, fuck you. I'm like, fuck you. Fuck you. Hold on, wait, before I go, y'all make sure y'all tap in with me to book your slot. A lot of y'all be hitting me up on Instagram and the email wanting to just talk about content, whether you're an up-and-coming content creator or somebody just got questions about cases or whatever. Book your consultation with me now. The information is on the screen. Hey, make sure you get your slot, because my slots be filling up fast.
This is the weakest, give a fuck about what they scream.
Holla!
Shout out Mickey. Mickey, you gonna be big. Like,
I'm trying to conquer the world, coming from where I come from.
Hey, this your girl Mickey Truth, #1 blogger in South Carolina. #1 blogger in South Carolina.